Well, good afternoon, everybody. Thank you for coming out, logging on and joining our today's seminar. My name is Steve Auger, and I'm Assistant Vice President for Major and Planned Giving at Sacred Heart University. Our seminar today will be a question and answer format, so feel free to use the chat box on your screen, send in any questions you might have. And while we can't provide individual advice for individual situations or legal advice, we will try very hard to answer the questions that you have. This seminar is also being recorded, so you can share it with your friends and family and view it again later. In my role, I work with many university alumni who are looking for ways to support the university through their estate plans. And whether it's Sacred Heart or the local food bank or local animal shelter, I strongly recommend that you consider that in your planning. It doesn't cost you anything now, and it's a great way to make a difference in the future. Many other alumni have called with questions about how to ensure that their assets are passed down or left to the people that and causes that they care about, or how to structure their estate to minimize taxes. So I hope we can answer some of those questions for you today. So today's seminar is life and legacy planning. And when we think about estate planning, we usually think about making a will. Today's seminar is a different way to look at estate planning. So our guest today is Laurie Giles Shipp. Laurie received a bachelor's of psychology from Springfield College. She received a master's in higher education administration from East Nazarene College and her law degree from Rutgers University. Laurie is the recipient of many numerous professional honors, including Best in Fairfield County, American Institute of Family Law Attorneys, she's ranked 10 best, National Black Lawyers Top 100, and AVO, which is a rating service that ranks attorneys, has rated her with their highest rating of a 10. So with that, I'd like to introduce Laurie.
Steve, thank you so much for having me. This is a topic that is near and dear to my heart, and I'm really excited about this opportunity.
Well, thank you for agreeing to do this. So the floor is yours.
So I guess the first part is, do we want to bring the slides up and begin with the life and legacy planning? Okay. So, and Steve, feel free to interrupt me when if there are any questions, because this is a very different aspect of the law and a different approach to estate planning. So I'm open to questions. So
Wonderful.
the first slide essentially is want to flip to the next slide? Perfect. So first question, what is life and legacy planning and how does it differ from estate planning? And the simple answer to that, and we will get much more detail, the simple answer to that is life and legacy planning is the here and now, where estate planning prepares for what happens after you die. But from the time you retire or your life in general, it's important to make sure that A, you're protecting your assets, and B, you're planning for the legacy that you would like to leave. So life and legacy planning allows you to live the life that you're working incredibly hard to have and to leave the legacy that you would be proud of. So if we look at the next slide, traditional estate planning. So with a traditional estate planning, it's very inexpensive in the beginning. Essentially, there's a will, last will and testament like our grandparents had, and it's very inexpensive and it's quick. It's very one size fits all. It doesn't take into consideration family dynamics. It doesn't take into consideration very specific aspects. It's just when I die, I want my children to have whatever I have left. It's a single document generally. And it provides, as I said, for distribution of assets after death. There's some cons, so those are the pros, and there are some cons. If we look at the next slide, there's a high back end cost. When you have a traditional will, your estate goes through the probate process. So the problem is that the probate process is going to cost your estate 3 to 6% of its value. So there, and lawyers' fees and probate fees, etc. So that cost is significantly higher than doing a life and legacy plan. It's a cookie cutter, one size fits all approach, as I indicated before. It requires probate approval for distribution. The key here is it doesn't provide for asset protection during life. And we all hear so much about generational wealth building. A traditional estate plan does not allow for generational asset transfer. So essentially, under the typical will, your house, your investments are distributed, and it doesn't provide for ongoing generational wealth building. And here, it does not provide for the use and maintenance of heirloom properties. So many people here in Fairfield County particularly have summer homes, weekend homes in Vermont, Massachusetts, Colorado, ski places, etc. And that's the place where so many great family memories are made. Christmases, Hanukkahs are spent there. With the traditional estate plan, that property essentially is sold off and distributed. There goes all of the family memories. So, why a life and legacy plan? If we turn to the next slide, life and legacy planning, the best thing is there are no administration costs or fees. Once it's established, there's no additional fee. There's no additional cost, and there's no need for additional intervention from anyone else. It's specifically tailored to meet your family needs. And when you pass away, the probate process is eliminated. Key, it protects those assets during life. And again, it sets a solid plan for generational asset succession, generational wealth building. You know, there are some cons. If we look next, there's a higher front end cost. Establishing a life and legacy plan and all the documents that go with that are much more complex than a simple will. And as a result, there is a higher cost. But I can say it's nowhere near the cost of 3 to 6% of the value of your estate. And it's a longer creation process. So creating this, because it's so tailored, because it's so meant to meet your personal needs, it can take anywhere from 2 weeks to 6 months to plan out. I think I was muted. I don't know that I'm still. So how does the approach to the life and legacy plan differ from traditional estate planning? It uses many more vehicles. For example, it uses a living trust. It incorporates life insurance as a form of payment for ongoing maintenance for properties. Very often there is an LLC formed. So there are LLC operating documents and formation documents. And then there are plan giving intention documents that are definitely incorporated within this. And as we also put in a durable healthcare power of attorney and a living will.
Before we move on, could you explain the LLC process and what it does and what the operating agreement is?
So an LLC is a limited liability corporation incorporated through the Secretary of State's office, and it's a separate corporation. We often put the heirloom properties or investment real estate into the LLC so that it goes for generations to come. The operating agreement can be very specific. For example, I've done some where the family has said that anyone using the family cottage must be over the age of 18. At no point is it to be rented out, and those type of things. So it's how do we now maintain this property or once the original owners have passed on?
So this is an agreement between family members, or is this agreement, how does that work?
It's a legally binding operating agreement that is this, it's essentially like bylaws with a nonprofit organization.
Mhm.
Nonprofit organizations have a set of bylaws that govern how the operating is going to happen. That's what an LLC operating agreement does. It's essentially a set of, for lack of a better word, bylaws that dictate how the property is to be used, the maintenance, et cetera. If there's going to be a buyout for people who don't necessarily want to be part of the LLC generationally, there's a provision often, more often than not, that says that allows for that buyout of that family member.
Wonderful, thank you.
One of the other major differences with the life and legacy plan as opposed to a traditional estate plan is that we really use a team approach. Of course, there's the attorney and then a financial advisor and a CPA or tax preparer to ensure that the hand knows what the other is doing, to ensure that whatever plan is created is in line with your tax obligations or your tax situation, to make sure that there's full alignment with your financial goals and the vehicles that you are currently using. So it makes sense to have a full team approach to this.
So
So
where would someone go to find an attorney or a financial advisor or a CPA? Where would, if you don't have these people, in currently working with, where would you go to find them?
So with an attorney, I always say the rule of three. Research 3 potential firms and go and sit with them and decide who can best fit your needs, who has the experience and the understanding of your needs and your goals to move forward. With a financial advisor, many people, and I'm going to venture to say most people who have a retirement account, it's generally through a company such as a Merrill Lynch or Fidelity, or in the higher ed space, a TIA, CREF. Those plans, those institutions have financial advisors available to help you with those questions. And then in terms of the CPA, the same approach as with an attorney. Talk to 3. Very often we will sit with particularly the financial advisor and the family to figure out what's best. Because financial advisors can't give legal advice and attorneys can't give financial advice. So it makes sense to have everyone at the table to make sure it works well. I hope that answered your question.
Yes, it did. Now, the financial advisor through TIAA, usually that's a free service, isn't it?
Absolutely. I think that's one place where people don't take advantage of it. For example, TIA, for most schools who use TIA, they allow at least one financial meeting every year.
Mhm.
This
That's
is
true.
something that's built well into your plan. Use it. Use it to make sure that very often people will say, we'll use a TIA, and when you're doing your allocations, kind of just like guess at them. Don't do that. Go to an expert, go to someone who knows what they're doing. And those people are experts. Remember, financial advisors do best when you do best. They have a vested interest in your future.
Wonderful, thank you.
So if we look at the areas of law that are included in estate planning, obviously the trust law with the irrevocable trust and other kinds of trust, cottage law, which protects heirloom properties and investment properties, and real estate law.
Cottage law is not something we really hear a lot about. What are the ins and
No.
outs of that?
So the 5-second explanation of cottage law, and I don't believe many firms do cottage law, essentially is set out to make sure that the family heirloom property, as we discussed prior, is protected. To make sure that anything, any property, any real property, whether it is the family yacht or it is the little bungalow in upstate New York, anything that you don't want sold upon death of the original owner would use cottage law and the LLC format and put it into an LLC as opposed to a living trust. Anything that can be distributed at time of death or incapacitation would be put into the living trust. Interestingly, the LLC is a member of, the trust is a member of the LLC. So they aren't very connected, but they're able to operate separately.
Okay.
So let's get into some nuts and bolts of where we are. First question is, what is a living trust? We've heard the term 100 times, many times, and people don't really understand what a living trust is. Essentially, a living trust, the purpose of a living trust is to hold, to own your assets and shield your assets. It allows for asset management during life and distribution post-death. So some key terms to think of with a living trust. The first is the trustor. The trustor is the person who is creating the trust, who originally owns the property. The trustee is the person who manages the trust. The trustor and the trustee can and usually are the same person, particularly if the trust is being established when one is of sound mind and ability, they're generally the original trustee. Then there's the successor trustee that takes over when the initial trustee can no longer function in that role. There's the trust, and then the trust rests as everything that's owned in the trust estate. And the beneficiary, same as with a will, is, and same with a life insurance policy, the person or the entity who takes when the trust is distributed. So in that, it can be a planned gift, it can be your children, it can be any other person or entity that you wish to leave things to.
So very much the way that you would leave things if you were to just do a simple will.
Exactly.
Okay.
But I believe in my mind, this is much more specific because you can set parameters. For example, if you were going to do a gift or if a minor was a beneficiary, you can set very specific lack of obstacles is probably not the right word. You can set standards of when that minor would receive whatever has been bequested to them. So for example, very often we see that they are living a productive life and have completed a bachelor's degree and or work full-time for a period of X years, and that they will get part of it at different stages of life. Key to remember though, with a minor beneficiary, that portion is and can always be used for their health, education, and welfare. So while they may not get and should not get a lump sum, it can certainly be used for college tuition. The other thing with other beneficiaries, if it's a planned gift, you can be very specific that it is going to, say, scholarships at Sacred Heart, or very, very clear on the people, and you can set up how it's given. People who, for example, have decided to give to their religious organization, or can be very clear on how that money is to be spent. Where under a typical will, you leave that money to the entity, not for this particular activity
Mm.
with this particular circumstances. For some reason, I keep getting muted. The benefits of a living trust are to protect assets for Medicaid, and other benefit planning, to shield assets from liability in case of a lawsuit, protect jointly owned assets, and shield assets from creditors. So I want to just give a couple of examples of this. Just recently, I know of two elderly people who have gotten into car accidents that exceeded their policy limits. One person had a living trust. Her home was placed into the living trust, and so her home is safe because technically the trust owns the home. She does not. In the other case, the woman who had some level of dementia failed to pay her insurance bill, which is probably one of the first things of the onset of some aging ailment, such as dementia, where bills, et cetera, are not getting paid. And she got into a car accident, a relatively simple car accident, but now her home and everything she's worked for are in jeopardy. So the living trust will absolutely shield you from that. When we look at jointly owned assets, couples, married couples, cohabitating couples, very often have joint assets. And what I've learned through my parents' aging and illness is that while they are mom and dad, they aged at a very different pace. Their illnesses came very differently, much different time period. If the assets were not in a living trust, the spouse or the partner who is not ill, who does not need care, would lose most of their assets because they're not protected. I know of one couple where the husband had a stroke relatively early in life. He was in his mid-70s and ended in a nursing home where he needed 24-hour care. Because they're well earned assets, what they had worked so hard for, with the idea that they were going to help put grandchildren through college, were unprotected. At $20,000 a month, which is the norm for a nursing home in this area, their assets were gone. And at the end, 10 years later, unfortunately, that long care, the wife ended up with only a life use in the property that they owned. So understand that all relationships are going to end. And we need to be as aware that if the relationship ends or changes because of the onset or illness or death, you want to protect both people.
I think one of the things that we had discussed, and I thought it was a really great point, was establishing, the Medicaid clock. When that begins, and what is the age limit that you can start to, begin to put things into a trust to protect them? Is there an age limit, or can you do it anytime?
There is not an age limit, and I always say that you should start or establish your living trust and your life plan the minute you have an asset that you want to protect. My 33-year-old daughter just purchased her first home, and it will be in a living trust. Because if something were to happen to her, she could be destitute. If something were to, if she needed care, what would happen to her family? So for that reason, there is no time frame that's too early. And the clock starts as soon as the living trust is established with its own EIN number. And right now in Connecticut, there is a 5-year look back for Medicaid. So if you start the trust when you're in your 60s, 70s, and in good health, et cetera, the likelihood of you hopefully making that 5-year look back is great. It's the person who comes in their mid to late 80s and wants to do a trust. We're really playing beat the clock.
But you could do something like this in your 50s or 40s.
Absolutely. Or 30s for that matter.
And that's when the clock starts.
That's when the clock starts. And remember, with Medicaid, in the state of Connecticut, you are allowed to have $1,600 of assets and no more to qualify. $1,600 is not much money at all. So as soon as you go over that $1,600 mark, everything else is up for grabs should you need full care and with Medicaid or other benefits.
Good to know.
So there are essentially two types of trust. The first is a revocable living trust. It holds the assets, as I mentioned. Assets you can move in and out of the trust, meaning that you would spend money exactly as you spend money now. You would save money exactly as you do now. The problem with a revocable living trust, and this is something that's recently happened, is that post-death sale of real estate, title insurance companies are still requiring that people go through the probate process, which completely is against the purpose, one of the major purposes of a living trust. But you can't freely amend or revoke a revocable living trust. The other thing to point out too is that in the state of Connecticut, Title 19 Medicaid for nursing home care does not consider a revocable trust as a protective vehicle. And there are some different IRS implications if you have assets above that $12 million threshold.
So the $12 million threshold is which?
The $12 million. My experience level on the $12 million threshold is not very large, but 12 million, if you have assets above $12 million, the IRS may require that it is in a revocable living trust, that then an irrevocable living trust becomes the beneficiary. It's much more complex once you've gone over the $12 million.
Okay.
Then there are irrevocable living trusts. They too hold assets. You move the assets in and out. You have the limited ability to modify or amend. The state of Connecticut has just recently, in the last 2 years, allowed for some amendments to irrevocable trust. For example, beneficiaries can be changed under certain clauses. You can sell real estate without court approval post-death, and it shields assets for Medicaid and other benefits and programs. And when I say that you can move assets in and out of the trust, again, you spend the money or the asset, or you purchase assets as you would as an individual. Now, kind of look at it. If you have a marriage, this is that third person in the marriage that you don't mind being in the marriage. It's kind of the other woman or the other man. So cottage law, we talked about a little bit. It utilizes an LLC-based strategy to protect the assets. And then heirloom properties, investment properties, and multi-owner properties. The heirloom property is something that most people don't think of. But the problem with the family cottage or the family vacation space or whatever it is, that's where we run into problems. Because if you have, for example, 3 children and only 2 of them want to maintain that property, unless it's protected, and we find cottage law is the best way to do this, unless it's protected, that one child could force a sale of the property and no one would have access. And then if we move down multi-generationally, perhaps there are 6 grandchildren and one grandchild, while everybody wants it, can't afford it. They're 6th of a responsibility for it. With that, that's where we use an insurance policy to enable everyone to enjoy the property, because the insurance policy, which is taken out on the life of each generational person, is enough to pay for the upkeep as well as do any buyouts. Buyout figures are established upfront. So many families will say a portion of the assessed value or says specific dollar amount. It also comes in when you have investment properties and multi-owner properties.
How
So,
does
go
a
ahead.
multi-owner, just talk about that with a multi-owner property, and
Mhm.
who are those individuals, and how does that differ from just like a traditional will-based
So
transfer?
if someone has purchased a property with a friend, with a sibling, uh, those properties would be held in the LLC. So when one owner passes away or becomes incompetent, it will not impact the ownership of the property. So everyone will be able to maintain the property as it would be. Under a will, it would be part of an estate and it would have to be sold or distributed or something. So the multi-owner property, in theory, you could leave it to your co-owners. That doesn't necessarily work out well in reality, especially if you have a multi-owner property and it can get very messy and very sticky as to who controls it. With the
Mm,
LLC, that's set up front.
okay.
So what are the next steps? First, determine your long-term needs and wants. Now, this is a tough topic to talk about, right? Especially when we talk about ends of life. But the question is, would you want to go into a nursing home? Do you not want to go into a nursing home? Do you want to age in place? What is the legacy that you want to leave? That's huge. Do you want to have your name on a building at Sacred Heart? You can prepare for that. Do you want to leave to your grandchildren or your great-grandchildren? Think that through. Create your team, get your lawyer and your financial advisor and your insurance agent, as well as your tax preparer or CPA on deck, start meeting. And then gather documents. And those
So
documents would be assess what assets you have, property deeds, bank accounts, insurance policies that are in place, any investment vehicles, again, any documents that you want to, that support what you're trying to do. Be very careful also, if you have a special needs, for example, child or a grandchild, this will allow you to protect as well. So come armed with all that information so it really fits your situation.
Okay.
Any other questions?
Well, walk me through, if you will. Now, someone comes to your office and wants to find out or implement um, this living trust. What are the kinds of things that you're asking them? What's the information you want from them? What's the discussion like?
So the initial discussion, I want to know what they want. I want to know what's important to them. So that gives me a better idea, and I want to know their family situation. I want to know if they have minor children or minor grandchildren. I want to know if there are family memory pieces or heirloom properties. We get all of that information. It's not simply what's your name, what's your spouse's name, who's getting what when you pass away. It's much more detailed. It's what are your current investments? What are your goals? Do you have a financial advisor? Do you have a CPA? I really try to spend a lot of time really understanding that family or that person. If, for example, they don't have lineal heirs, children, then what is their plan? How do they want to be remembered? How do they want their care and services when they get older? All of those pieces, so personal. It's so in depth and personal. So that's how the process would start. And then we would kind of draft a very basic outline of a living trust and start having them discuss it with their financial advisor. And like I said, very often we sit with the financial advisor and the client, which I prefer. This way I know that I'm doing the right thing for that person. And then we go from there. So it's a matter of working it until it is the perfect or as close to perfect for that person.
So who are the people who should go to your office? They're coming to do this living trust. Who are the people who you want to see?
If I want to see the person who's the name truster. So if it is a husband and wife, if it is cohabitating couple, if it's an individual, whoever's going to be the truster is who I want to meet with. And it's very important with all estate planning or living life and legacy planning for me to meet in person or at least through a Zoom so I can gauge the competency level. That's the most important thing in terms of the liability for an attorney to make sure that the person is competent. And I can't do that on a phone call.
Do you want to invite, for instance, a married couple? Do you have their children in the room? Are there other, friends? Are there other people who should be part of the process?
So I like to meet with the trustor first. And then we will do family meetings because quite frankly, Steve, a lot of these conversations are tough conversations. And many clients through the years have wanted to bring their children into really so the children understand what's going on. They understand why mom and or dad have decided to do things the way they've done. So absolutely, first meeting, I like to do just the trustors, but after that, I am open to family meetings. And I think it helps. It helps a lot of families.
Mhm.
Families don't necessarily, all family members don't necessarily know what is happening in their parents' lives or in their loved ones' lives. And so sometimes it comes as quite a surprise to people. So this way, everyone's on the same page and we don't have the conversation after the fact of why did they not do X, Y, Z. And sometimes, for example, parents will loan one child significant amounts of money, so that child may get less at the end. Those conversations need to be had, whether they're in my office, whether they're with the financial advisor, whether it's with me as well as with the financial advisor. or whether it's something they handle by themselves, we make sure that those conversations are had.
Okay. There's other documents that we usually talk about when we talk about estate planning, things like power of attorney and advance directives. Where do they fit into this process?
It is all part of it. And again, it makes sense because we're talking about having you live your life. So advanced healthcare directives, powers of attorney are very, very important. Within the living trust, there is a financial power of attorney. But I also like to do a separate power of attorney in case something that should have been in the living trust didn't get in until the person is in, and the person becomes incompetent or passes away. The durable healthcare power of attorney is so important. And you know, the statistics on that are very scary. Very few Americans actually do this. And nothing could be worse for your loved one to have to make a decision about your health care without at least the knowledge of what is it that you would want. And while only 12% of the people in America die suddenly, 12% is a lot when it's your relative. So those are important. It's the durable healthcare power of attorney allows someone to carry out your wishes, and the healthcare power, the living will states your wishes. And that's another conversation that families absolutely positively have. I can't tell you how many times I've had the conversation where someone is saying, but mom would have wanted this, and a sibling is saying, no, she wanted this. Have the conversation.
Yeah, that's speaking of the conversation, before the family gets to you, to your office, what kind of communication should they be having?
Of and this is a very broad statement, a very open communication. Very often people, as we age, and even before we age, we don't necessarily want to share our financial information with anyone, children included.
Mm.
So I think it's important to say that, but to leave it so that it can be found. And end of life discussions are incredibly difficult for many families, but they're conversations that have to be had. So families should be talking about the life plan as well as the legacy and the end of life decisions. And those, like I said, those are really hard conversations to have.
Mm. Yeah. We do have a question. Is it a good practice to sign more than one original of the power of attorney and/or healthcare proxy appointment?
No, no, because that can lead to problems. There should be one original and copies. And many people will leave the original, the original should be left in a place where it can be found. Some people keep it on file, which I don't know, this is a great idea. Some people keep it on file at the records department or a hospital or with their doctor. Keeping it on file with your physician is not a bad idea. But or digitize it, but having more than one copy can lead to a nightmare because if it can be used by multiple people, not a good idea.
Well, that leads to another question. The documentation for all of this, whether it's a healthcare proxy or it's end of life wishes and things like that, where should that documentation be held? Because frankly, some of it is after the fact, it's, you will need to take to a lawyer or to the court or whichever, but other things you may need to use before the person passes away or
Mhm.
when the person passes away. So how accessible should that be?
So if you do the life and legacy plan, you won't have to take it to a court, but we invariably put it in a binder for people, large binder, and it's kept in their home or wherever that's accessible. And that would have all of your documents and notes to the family or notes to whomever as to what your wishes are. So to me, it's kept in your home. I know many lawyers will keep the original documents in their office. That has never worked for me because number one, I hope to be retired long before any of my clients pass away. And number two, what if I'm away? What if I'm on my dream round the world trip? How are you going to, and you need your document. You don't want to wait till I come back. Or
Mm.
if I go out of practice or whatever is going on, or I become incompetent. Keep your documents, in my mind, yourself.
And accessible,
Absolutely.
not locked
Accessible.
in a.
And make sure people know where they are. And just as an aside, particularly for people who have challenged health or elderly people, we also recommend that you keep a list of your medications, etc., taped to your refrigerator. So if an ambulance has to come to your house, then there's a list of medications, etc., that go with you. Or if you travel, keep that list accessible or in your car. No questions. You don't want to have a physician who is not familiar with your case have to go through and figure out what medications you're on. So just as an aside, just that little, dear ambulance driver, take this with you.
Good advice. Good advice. We've pretty much come to the close. We've answered the question that was in the chat box. And is there anything else you'd like to just to sum up what we've covered today?
So for me, the summary would be to prepare your legacy, but live your best life. Live the life that you have worked hard to achieve or you are working hard to achieve. That's my strongest advice.
Okay, that's good advice. Well, I thank you so much, Laurie, for joining us today and for the advice. This is a very different way of looking at estate planning, and I think something that many people will be able to use and be very functional for them in their own situation. So I thank you very, very much for taking the time and joining us today. And
Thank you.
it's as I mentioned before, this will be available. This is being recorded and will be available through a link that we will send all of the people who registered for this. And it will also be available on the Plan Giving website at Sacred Heart University. So if you have friends or acquaintances or other family members who wish to look at it and you can't access the link for some reason, it will also be posted on the website. So we certainly encourage you to spread the word and take advantage of it. So thank you all for attending, and if you have more questions, feel free to give us a call at Sacred Heart Plan Giving Department, and we will certainly hope to find the answers for you.